Do you have any clue on who this stylish man is? If you don't, let me tell you who it is. This is John Jay. He was born on December 12, 1974 in New York to a wealthy family whose father was Peter Jay and mother Mary Van Cordland. John Jay was homeschooled by his mother until he was 8. Then he was sent to New Rochelle to learn under an Anglican priest named Pierre Stoup. Then, when he was older, he graduated from King's College in 1764 and entered into the bar program in 1768, where he had a successful lawyer career. George Washington appointed John Jay as the Chief Justice of the United States. Originally, he had planned him to be the Secretary of State, but John Jay declined. When George Washington offered up the position to be the Chief Justice, he accepted. He served in office from 1789 through 1799. Some cases that John Jay was involved in was Chisholm versus Georgia. This was technically considered the first case for the Supreme Court of the United States, and although there wasn't any significant information on it, it was settled through the 11th Amendment in 1795. West versus Barnes in 1791 was the first U.S. Supreme Court decision and earliest case for the verbal argument. It was argued on August 2nd, 1791, and then it was decided on August 3rd, 1791. Finally, Van Stopforth versus Maryland in 1791 was the first case agreed to by the United States Supreme Court to be heard and decided. Unfortunately, or fortunately, depending on how you look at it, the suit was settled before the oral arguments commenced. John Jay was actually a pretty good negotiator. I believe this is due to the fact that he was a lawyer and he had a pretty successful career. Using this skill, he actually negotiated for the Treaty of Paris to be signed. He was actually a loyalist before also. He wasn't always the patriot. And as the Revolutionary War grew on, he became more radical. And while the Declaration of Independence was being signed, he chose not to sign it because he believed that independence was not the best choice. John Jay passed away on May 17, 1829, in Bedford, New York. He died due to a stroke. After that, he was buried on his son's farm on a family plot they had in Westchester County, New York.
Were you aware that there were many Supreme Court cases between blacks and whites back in the days? Plessy versus Ferguson was a Supreme Court case that occurred on May 18, 1896. The people who were involved with the Supreme Court case were John Ferguson and Homer Plessy. John Ferguson was born on June 10, 1838 in Chilmark, Massachusetts. He was an American lawyer and judge from Louisiana. He was the defendant in the court case. Homer Plessy was born on March 17, 1862, and he was a Louisiana French-speaking Creole plaintiff. The Separate Car Act was put in effect due to this case. The Separate Car Act was a law passed by the Louisiana State Legislature in 1890, which required equal but separate train car accommodations for blacks and whites. What happened was that Homer Plessy refused to sit with the blacks on a train, and he was arrested due to sitting in the Louisiana Railroad car designated for whites only. In 1896, the Supreme Court ruled that the law was allowable. However, in 1954, the Supreme Court reversed the decision. However, in 1964, historian Van Woodward pointed out an article about how Plessy versus Ferguson, white and black Southerners mixed relatively free until the 1880s when state legislators passed the first laws requiring railroads to provide separate cars for colored passengers. Southern blacks had then just witnessed the dawn of the Jim Crow era, and members of the black community in New Orleans decided to mount a After the Compromise of 1877 led to the withdrawal of federal troops from the South, Democrats consolidated control of state legislatures throughout the region. At the heart of Plessy versus Ferguson was a law passed in Louisiana in 1890 for providing separate railway carriages for the white and colored races. It stipulated that all passenger railways had to provide these separate cars, which should be in equal facilities.